They have then taken up another point on the question of forms. There is an affidavit that indicates that there are unclear forms. You will find an affidavit by a gentleman called Brian Omwenga, who saw our affidavit. This was the question of the Kim's kit taking photographs. Mr. Omwenga has indicated with clarity why each and every of the forms cited there had difficulties, and he has also attached the form, we got the physical form, showing that there was absolutely no problem. But in resolving these questions, and this is a respectful and humble petition to the court, please consider the provisions of Section 72 of the Interpretation and General Provisions Act. Please do also consider the provisions of Section 26 of the Statutory Instruments Act, which is in similar terms to Section 72. And finally, please do consider what this Honorable Court said at paragraph 133. Paragraph 133 of Raila 2013, where you took judicial notice of the fact that some of these forms, photographs and that kind of thing, are taken in dimly lit corners of Great Republic, but where power is a problem, and so it's dark sometimes, and the problems of that nature, and you took judicial notice of that fact. I move on from there now to a point, I think that, please permit me 2 or 3 minutes to say something about the attack on the appointment of returning officers. On the 25th of October, while we were seated here waiting to hear a case, yet another case by the second petitioner here, I believe on that occasion he was trying to stop the election. I think we were watching TV and noted that there was a decision being handed over at Milimani concerning the appointment of returning officers. You will find our answer at paragraphs 98 to 104 of the affidavit of Mr. Davis Churchill. Now, one, that case was heard without notice to us. We were not invited to be party to that case. And that was a requirement of the provisions of Order 54 that deal with judicial review orders. Any party directly affected ought to be invited. It was not the first time a similar case had been brought. We had had another one prior to the 8th August election, and in that one, we participated. Now, it makes a difference because in the one before 8th August, we actually recorded a consent on that issue. So it wasn't an issue during the general election. Unfortunately, this time, for some reason, we were not invited. Number two, the provisions of Regulation 3, Subregulation 2, must be read as circumscribed by Regulation 89 of the General Regulations. It's an important regulation because Regulation 89 says that the regulations are to be applied to a fresh presidential election with such adaptations and modifications as are necessary, because it's not like a general election. So it is different to that extent. Number three, the petitioner in that case, so the applicant in that case, who's the second petitioner here, indicated in that case that the parties he had consulted to find out whether they were consulted, because it was a consultation issue, were ODM, ANC, and Chama cha Mzalendo. He went and consulted the parties who had said there will be no election, and did not consult the ones who said there will be an election. And so there's a bit of irony there, and an injustice. They didn't come to ask us, and none of the other political parties, none of the other independent candidates have said they had a problem with these appointments. But the party that didn't want an election goes to court to say they have a problem. And so please do consider that when you review that particular point. Now, there was an issue that arose in Judge Mativo's decision in the Uhuru court case that has some relevance to this question as well. And it dealt with the question of the absurdity of forcing dates in a contest that had constitutional timelines that made it impossible to do so. And so please, again, do consider that point. And a very important point, and you will find this in the letters attached to Davis' affidavit at page 40 and 41. The second respondent, the chairman of the IEBC, did in fact call us for meetings to discuss all these things. We were called for what was being called stakeholder engagement. And the problem was One party said, the only thing we can come to discuss with you is your resignation, number one, and whether there will be no election. And it became very impossible for this consultation because Rule 3.2 deals with consultation. But the parties being called to be consulted do not want to be consulted other than firing you. And so again, please do consider that when you retire to write your judgment. My time is beginning to run out. The court, I'm told it has run out a long time, but